Good morning, this is your Kelso Report for Tuesday, September 25th, and I'm your host, Clark Kelso. Well, we have three cases today. The first dealing with a civil rights claim and a coerced confession. Family law is our second case involving termination of parental rights, and our last case involves the confidentiality of quality records for a hospital. Now, just yesterday I noted that courts oftentimes give inmates without counsel some help in dealing with court procedures. Although in our case yesterday you will recall that the court drew a line and held that an inmate still had to exhaust administrative remedies so long as those remedies were knowable. Well, a majority panel of the Ninth Circuit pretty much threw the lines away entirely with its decision today in Hall versus City of Los Angeles. Now, the facts are definitely sympathetic, which is what drove the majority's decision. The plaintiff here had been falsely accused of a double murder back in 1983 by several jailhouse informants. After several interrogations, including a 6-hour marathon session, where the police, among other things, gave the plaintiff reason to fear that his life would be in jeopardy from a gang leader if he did not confess to the murders, the plaintiff broke down and acquiesced in a confession that was virtually dictated by the police officers. He was convicted in 1985 and was not released until 2004 when the federal courts granted his habeas petition, which was based on the allegation that his conviction was based on falsified documents in violation of due process. After his release from prison, he sued the City of Los Angeles and several of the involved police officers, asserting, among other things, a fabrication of evidence claim under the 14th Amendment. After one appeal from some early procedural rulings and a remand, the district court granted summary judgment to the defendants on the 14th Amendment fabrication of evidence claim. The Ninth Circuit affirmed the grant of summary judgment, concluding that all of the case authorities dealing with fabrication of evidence related to fabrication of third-party testimony. Instead of a fabrication of evidence claim, what the plaintiff should have claimed was a coerced confession in violation of the Fifth Amendment. But the original complaint did not include such a claim, and the district court had long ago, before the first appeal, denied the plaintiff's request to permit an amendment to add that claim to the complaint, a decision the plaintiff had not even appealed. Now, notwithstanding the absence of a prior appeal on this issue, and even though the plaintiff had not himself raised the issue on the current appeal, the majority decided to remand the case to the district court to give the plaintiff the opportunity to amend the complaint to add a coerced confession claim. The only justification for this unusual action given by the majority was that, quote, the exceptional circumstances in this case persuade us that a remand is necessary to avoid manifest injustice. Close quote. Well, did the majority go too far in helping out this time? The dissenting judge clearly thought so. According to the dissent, quote, the majority disregards the most basic principles of judicial restraint, erroneously overturns a district court decision that we have no jurisdiction to review, and gives the appellant relief that he never asked us to give, close quote. So it looks like the majority helped this particular inmate plaintiff out with pretty much everything. An unusual case, to be sure. Next, we turn to a case involving termination of parental rights. And here, I really cannot improve upon the opening paragraph of the decision in In Re Marcello B. A tragic case involving the loss of parental rights because both parents were long-time, apparently incurable alcoholics. Here's how the case began. The opinion began, quote, the adverse consequences of alcoholism are well known. People have the power to become alcoholics, and as long as they do not victimize others, the law, generally speaking, leaves them alone. As family members will attest, there are silent victims in the wake of alcoholism. Here, One of such victims is the 5-year-old son of 2 such people. They are deeply entrenched in alcohol as a way of, and perhaps as an end to, life. The judiciary has been tasked by the legislature to protect children. There are many adverse consequences to alcoholism. We add one more: loss of a child through legal termination of parental rights. Close quote. The mother's sister and the father's brother both testified in favor of the termination of parental rights, noting that their siblings were hopelessly addicted, and there was a history of domestic violence and situations where the child was left in potentially dangerous situations with both parents incapacitated. A terrible tragedy, this case, for all involved. Next, we turn to hospital records. Modern healthcare systems and hospitals have formal quality improvement programs that are given special protection from the ordinary rules of discovery, so that the improvement programs can do their work without fear that their documents and records will show up in litigation against the healthcare system or hospital. In California, Section 1157 of the Evidence Code provides that, quote, neither the proceedings nor the records of organized committees of medical staffs and hospitals having the responsibility of evaluation and improvement of the quality of care rendered in the hospital shall be subject to discovery, close quote. Section 1157 embodies the legislature's belief that external access in litigation to quality improvement committee information would stifle candor and inhibit objectivity in the committee's processes. In Pomona Valley Hospital Medical Center versus Cabana, the 2nd District faced the question of whether Section 1157's protections extended to the work of the hospital's Institutional Review Board, which has the responsibility of reviewing and approving the initiation of all biomedical research involving human subjects. The IRB was involved because the plaintiff was scheduled to undergo surgery to correct back pain through the fusion of 2 vertebrae, where the surgical procedure involved the use of a type of putty and bone void filler that had been granted only limited approvals by the FDA for individual use, but not for use in combination. Because the combined use was experimental, the IRB was required to review and approve the use of the products before the plaintiff's physician could use it. And the IRB's review included communications between the IRB and the product manufacturer. Well, the surgery failed to correct the plaintiff's problems and allegedly made her pain worse. She sought the records and communications of the IRB related to her case. The 2nd District held that the IRB was an organized committee of medical staff under Section 1157, even though several members of that committee were not doctors. As the court noted, nothing in the language of Section 1157 requires that a medical committee be composed only of physicians, and the IRB's work clearly was part of the hospital's quality improvement and peer review processes, bringing the IRB and its records within the scope of Section 1157's protections. And that's it for today's Kelso Report. Have a great day in the law.